Hi, everyone. Welcome today. We'll give it a couple more, about a minute or so to let some other folks come on in. But we're excited to have you all here today on this little bit of a rainy day, but that's okay because we need the rain here. It looks like there's a few more people in the waiting room that are joining. So again, we'll give it just a couple minutes. Hi, everyone. We'll get started in a minute. Welcome today. Okay, it looks like everybody that was in the waiting room is now here in the virtual space. So we will go ahead and get started. And I suspect we'll have a few more people coming and going throughout the hour, which will be okay. We are delighted to welcome Sarah Nussbaum here today with us. She is from the Office of Public Guardian at the state of Vermont. She holds a BA in psychology as well as earning her JD. And she's been a public guardian in the Office of Public Guardian since 2017 and has served in her current role as director since 2024. So without further ado, I'm going to turn it right over to Sarah to start the presentation. Just a couple quick housekeeping pieces. We ask that you just stay muted while Sarah is going through this presentation. If you do have questions, feel free to pop them in the chat, or you can raise your hand. I do want to disclose that we are recording today's session. So if you are more comfortable popping a question in the chat, Michelle and I will be kind of manning the chat, and can ask questions on your behalf. At the end of Sarah's presentation, we will turn off the recording to allow for a more comfortable setting for people to ask questions, so that it won't be recorded. All right, so Sarah, I'll turn it over to you. Thank you.
Great, thanks. Hi, everybody. I can't actually see most of you, but I know you're there. So today we're going to be talking about decision-making supports and surrogate decision-making, which, as you'll hear, includes guardianship, but also includes a whole host of other support strategies, which we will get into. So as Alyssa said, I'm from the Office of Public Guardian. So a little bit about our office, for those of you who are not familiar. We are housed within the Division of Developmental Disability Services in the Department of Disabilities, Aging, and Independent Living, otherwise known as DALE. We have a staff of 33, which includes 29 full-time guardians. And we serve persons in need of guardianship, which is a statutorily defined term, when there's no private guardian available. So we are sort of the guardian of last resort, essentially. We serve adults with developmental disabilities, so 18 and older with a developmental disability. And we also serve older Vermonters who are defined for us as individuals who are 60 and over, who have some sort of cognitive impairment, which makes them in need of a guardian. So there's definitely a gap there of adults who don't fit in either of those categories, who may very well need a guardian, but public guardianship is not available to them as an option. We served 556 people with developmental disabilities in fiscal year 25, and 205 people with older Vermonters. So you can see with 29 full-time guardians and around about 700 people under guardianship at any given time, guardians' caseloads are fairly high, and it's a pretty labor-intensive role. And the number of guardians does not change. So it's not as if we get in a whole bunch of new petitions, we can then expand our staff to maintain sort of any kind of caseload. be within any caseload limits. So there's not, unfortunately, really anything we can do about that. The numbers sort of are what they are. But we definitely do work with community partners in thinking through individual cases around what's really needed. Is it guardianship? Are there other individuals who can serve as guardian? Just A, because that's good planning, but also B, because we just really can't serve people well if we just have overwhelming numbers. So in addition to guardianship, we also provide education about guardianship and alternatives. We provide rep payee services, mostly to people who we are also guardian for, but occasionally for people for whom there are no other good alternatives. We provide assistance to private guardians, both people who are actually already guardians as well as people who may be considering whether or not to take on the role of a guardian of an adult. And then we also arrange the court-ordered guardianship evaluations, which are part of the process of getting a guardian appointed for someone. We cannot ourselves petition for guardianship. So we get a lot of people calling who would like a guardian, maybe would like a public guardian, and are hopeful that just by calling us that somehow that sets off the process. But that is not the case. There needs to be a petitioner outside of our office, which is a bit of a responsibility. And sometimes that's part of the problem in a given particular situation, is who's actually going to be the petitioner. So there is sort of a continuum of decision-making supports. As you can see, guardianship is on the most restrictive end in that it actually involves a restriction of rights. And that's why there's a court process involved in getting a guardian appointed, because the person who has a guardian then actually loses their right to actually make their own independent decisions. And so we really only want to take that route if there really isn't any other reasonable alternative. All the way at the other end are sort of very informal supports, like release forms, which just would give somebody of the person's choosing access to records, so medical records. That's where it comes up most. Could be school records, anything, information that would allow somebody to assist a person with decision making, give them access to the information that would help them assist with decision making. For financial issues, there's all sorts of other kinds of informal supports, like for banking services. What we mean by that is like auto deposit, auto pay, other bill pay kind of services. Separating out banking accounts so that personal spending money is only in one account, which helps prevent somebody from overspending. Support services in and of themselves are often a good alternative to guardianship. So somebody may not be able to be fully independent, either in activities of daily living or decision making, but with some support services, with case management, with social work services, they may do fine in making decisions with that help. And then stable accounts are just another form of savings, which allow people to have savings without jeopardizing any benefits that they might otherwise be entitled to. Then in the middle, there are some areas that we're going to talk about. Supported decision-making agreements, rep payee and trusts are useful for financial help. And then powers of attorney and healthcare agents are also very specific areas of decision-making, can be covered in those sorts of agreements. So supported decision-making, what is that? That is, it's sort of a broad term, which encompasses a range of different models that help a person with a disability make decisions in their life with people who they have chosen to be their helpers, both in coming up with the decisions and then communicating those decisions. Some states have now incorporated supported decision-making into their statutes in the way that Vermont has statutes addressing advanced directives and powers of attorney, which gives the supported decision-making agreements the same sort of legal force as an advanced directive or a power of attorney has in Vermont. Vermont has yet to do that. I think there's a movement to make that happen, but it hasn't happened yet. It does not detract, though, from its usefulness currently, and it's something that should definitely be explored for people for whom that just makes good sense. The person wanting the support gets to choose the people that they want to act as their supporters. And then in turn, the supporters agree that they're willing and to help the person understand, consider, and communicate their decisions. And there's a whole variety of ways that that agreement can look. One of the benefits of not having supported decision-making in statute yet is there's no prescribed form that these agreements have to take. So they can really be written in the way that works best for the person that we're trying to support. So if that looks like pictures and other more simpler ways of communicating what the agreement is, they can be written that way, or they can look sort of more formal, like a contract. Either way is acceptable. So it's important when you're writing a supported decision-making plan that it's labeled as that. This is what we're doing. We're setting up a supported decision-making plan for this particular person. So it identifies who the person is who's being supported. It's identifying what decisions the person needs supporters for, because not everybody who needs help with making decisions needs help in all areas of their life and with all decisions. They may just need help in some areas. And then the plan also identifies who those supporters are going to be and in what ways they're going to provide the support. Maybe the person just needs help with communicating their decisions once they've made them. Maybe they can communicate just fine once they know what the decision is, but they really just want supporters to be part of the decision-making process with them. So it lays out all of those things. The recommendation is that if financial decisions are included, that there's someone, a monitor is what it's called, someone who's sort of overseeing that as well, so that it's a little bit of a check, just to make sure that your financial decision maker supporter can't take advantage of being in that role. If as part of the supported decision-making plan, for example, you have somebody who's going to support with medical decision-making, then you may want to also consider what releases are needed so that that person might have access to the medical records, let's say, so that they can have all of the information that they need to be able to provide support to the person who's going to be making the decision. Then everybody signs the agreement. And as I said, we have a lot of flexibility in Vermont right now to write it up in the way that works best for the person who's being supported. So this is just an example of what a supported decision-making agreement could look like. And again, it's just laying out like what areas do they want the support in, and how they want to be supported. And then how they're going to, if they want help with communicating their decisions, how they would like that help. And then the supporters are identified. So some questions around supported decision-making. Is it a contract? And this is important because if it was to be considered a contract, there might be some people who would not be able to be a supporter. For example, if somebody's receiving services and has paid support staff, if a supported decision-making agreement was considered a contract, then those paid supports might not be able to also act as supporters. But since it's not considered a contract, then paid support staff could be used as supporters under a supported decision-making agreement, which is great for the person wanting support. If those are the people who are in their lives who they feel closest to, then it still means that a supported decision-making agreement is possible for them. What happens if the person with the supported decision-making agreement ignores the advice of their supporters? They can. So there's nothing that requires that the person take the advice of the supporters. They still have the final say in their decisions. Likewise, if they don't even seek the advice of their supporters, that's also allowed. Now, it could be that a person is in need of help with decision making, and a supported decision making agreement is sort of tried out as a first step and seeing if that kind of support will work for them. And they may not have any interest in taking the advice of their supporters, or basically just ignore the whole agreement. And that may mean that whatever the issues were that sort of presented themselves as the reason why the person might need decision-making support are still present. Then it might be, you might need to be looking at what other supports like guardianship might be more appropriate. But it depends. As we'll see later, guardianship doesn't solve all problems either. So the benefits of supported decision-making is it really puts the person in need of supports in control, gives them the final say, lets them say who they want to have in their lives helping them, and it can be very flexible. So that is one of the biggest benefit. So the other sorts of documents that can be in place to provide decision-making supports are advanced directives and designated healthcare agents. So these documents are in statute, and when they are signed and witnessed appropriately, then they do have legal significance. And the advanced directive, I'm guessing that you all perhaps have more familiarity with these sorts of documents than supported decision-making agreements, but maybe not. So the advanced directives can speak to a person's future wishes and preferences for treatment, or they can be as simple as designating the person that they would like to be their healthcare agent who will be making healthcare decisions for them. They don't need to be, in fact, there is a form that is just a healthcare designation, a healthcare agent designation form, if that's really the purpose, is to just put a decision maker in place, and the person isn't otherwise either at a place in their life where they're sort of thinking about future wishes and preferences, or maybe they're not able to articulate those future wishes and preferences, but they are able to understand and articulate who they want to be their decision maker. Then the healthcare agent designation form in and of itself may be all that they need. The healthcare agent has the same authority as a medical guardian. And in fact, if a guardian is appointed at a later date, the designated healthcare agent takes priority as the medical decision maker. So sometimes there's a question around whether or not the healthcare agent is appropriate as the decision maker. And so guardianship is sought in order to replace that healthcare agent. But that has to happen very specifically, meaning that the petition for guardianship has to be filed you have to seek medical guardianship, and you have to specifically request that the court sort of nullify that healthcare agent designation. Otherwise, they could appoint a medical guardian, and then you have two medical decision makers in place, and the healthcare agent takes priority. So it doesn't help to have just a medical guardian come on the scene. If there is a fully completed advance directive and the person ends up with a guardian, then the guardian has to follow the wishes in the advance directive. If there's something in that document which is no longer applicable or no longer seems to be what the person wishes, then you need to go to court to get the authority to make the change to the advance directive. You can just decide that on your own as the guardian. So who can do an advance directive or designate a healthcare agent? Any adult who does not have a guardian. So once you have a guardian, a medical guardian, then you no longer can complete an advance directive. That doesn't mean that the form can't be used as sort of a way to direct a conversation about a person's wishes and preferences. But legally, they can no longer sign an advance directive, and a guardian can't sign an advance directive on behalf of a person under guardianship. So completing an advance directive is a serious document. It has the force of law once it's signed appropriately, and so they really need to be filled out carefully, ideally with the help of a medical provider who can explain what the different sort of choices that you might be making are. We get lots of advance directives that include lots of wishes, which when put together don't form a consistent picture of what the person really wants, which if the person's able to articulate why they said what they said, then you can work through that. But if you're dealing with someone who can no longer articulate that or doesn't remember making the advance directive, then you're left with this document that's binding, but not really helpful. So it's really important that they're filled out carefully with a helper who actually understands what the different terms mean and what the different choices mean. And we use the Vermont Ethics Network all the time for the forms that they have on their website. A power of attorney document it used to be that power of attorney documents could reference both medical and financial, and people still sometimes call people powers of attorney when they're referring to healthcare decisions. I think older documents, they're still legally valid. But now when we refer to powers of attorney, those are specifically around financial decisions, or education decisions can also be included in a power of attorney document. But healthcare decisions now have their own separate, they're done in advance directives. Although I still think there are attorneys who are doing durable powers of attorney for healthcare, which I think is an older way of doing it and can sometimes be confusing because people sort of throw around the term power of attorney to mean they can make decisions about anything. And so it's important to look at the document to make sure that they actually have the authority to make whatever decision is they are presenting themselves as decision maker for. But now if you were to put together a power of attorney, particularly on your own, it would be just around financial. There are signing and notary requirements for power of attorney documents. And if those signing requirements and notary requirements are not met, then the document is not legally valid. So you can't rely on it. It might be useful as an expression of what the person wanted or had hoped would happen. But if it's not properly signed, then it's not actually legally valid. All right, so depending on what's happening in an individual's life, there are different alternatives to guardianship, which you might employ. So if the issue is around money management, if the person receives Social Security as their only form of income, then a rep payee might be the answer. That's someone who will manage their Social Security income and pay their bills and give them personal spending money. So it helps sort of budgeting and making sure that essential bills that allow somebody to remain housed and fed, that those bills are prioritized. Financial powers of attorney are useful. Veterans Affairs has their own fiduciary process. So if someone's receiving VA income, you go through the Veterans Affairs to have a fiduciary appointed. It's very similar to a rep payee, just a different entity. Banking services, as we talked about before, can sometimes be all that's needed to help somebody with money management. Just making sure that bills are getting paid automatically, money is being deposited automatically. Maybe there's a separate bank account for personal spending, so it just helps to limit overspending. Stable accounts we talked about earlier, and then if there's a trust, a trustee helps with managing expenditures. Healthcare decision-making, you could use a supported decision-making agreement if that's appropriate, an advanced directive for healthcare, or maybe it's really about medication. And so assistive technology for medication management can be helpful, automated pill dispensers, that kind of thing. If independent living is part of where supports are needed, if they are receiving services through some kind of agency, in the developmental services world, a shared living provider, that's what SLP stands for, or a staff department are two models of supported living arrangements that are possible. Section 8 and housing supports through those sorts of programs help finding apartment. There are independent living classes to help people learn sort of how to manage paying rent, paying utilities, what their obligations are as somebody living in an apartment building, for example. For employment issues, there's a supported employment programs and voc rehab. And then legal questions. There's legal aid who can provide answers to many legal questions. Or you can have a power of attorney in which your agent helps you with legal issues. Education, there are powers of attorney for education specifically. Supported decision-making agreements can also be used for that. Personal safety issues, services are often sufficient to help with personal safety issues. And then there's remote support technology, which can be really helpful in helping people maintain their independence, but have remote supports available in their apartment, for example, to help with medication and hygiene reminders, appointment reminders, and a way for them to check in if they need help with something, directions on how to microwave their whatever it is they're trying to microwave. And then just any kind of personal decision-making, case management, supported decision-making, and then maybe something like therapy or social skills groups could also be helpful. All right, so the most restrictive form of decision-making supports is guardianship. So what is adult guardianship? Guardianship can be a confusing term because it's also used for minors. And a guardian of a minor can often be someone who really looks and acts like a parent. But when somebody becomes an adult and has a guardian, that guardian is in a much different position. They no longer have a parent, and the guardian is not their parent. The guardian is someone who has surrogate decision-making authority on behalf of them. That's a much different role than somebody who's providing direct support to them. Guardianship is ordered either through the probate or family court after an evaluation of the person's need for guardianship. Most guardianships come through probate court. Family court only appoints public guardians for adults with developmental disabilities. It's a very specific group of guardianships go through family court. Guardianship orders are tailored just to the decision-making areas that the person needs. So somebody may need help in all areas of their life, or they may just need help in one specific area, maybe just medical decision-making, or maybe just financial. Those are the two that are often singled out as the single area that somebody needs help with. Guardianship powers include these sort of general areas. So there's general supervision, which sort of covers everything, like where does the person live? Where are they going to school? Do they have a job? That sort of general supervision. Medical and dental, financial, except for family court orders do not include financial guardianship, but all other guardianship orders can include financial if that's what the person needs. And then contracts, sale and encumbrance of property, and legal are the additional powers that may be included. There's two types of guardians for adult. There's a voluntary guardian and an involuntary guardian. A voluntary guardian, legal aid, for example, does not recommend voluntary guardianship for anybody because essentially the person who is requesting a voluntary guardian needs to understand what they're doing, what they're asking for. And if they have the ability to understand that they need help, they want help, and here's the person I want to have help me, then they have the capacity then to either identify a healthcare agent or an agent under a power of attorney, or participate in a supported decision-making agreement. And so legal aid would prefer that people not add the additional sort of barrier of court involvement by having a voluntary guardian. However, it is an option, and some people do choose to do that. An involuntary guardian it's basically just a different process. It's a lengthier process that involves due process because the person's right to decision making is removed from them. It doesn't necessarily mean that they are opposed to having a guardian. It just means that the process could happen whether or not they were opposed to it or even understood that it was happening. And then the process of undoing an involuntary guardianship is more involved, in that the person would need to come back to court and show that they actually don't need a guardian anymore. Not that they don't want one, but they don't need one. Whereas with a voluntary guardian, they could just go back to court and tell the court that they no longer wanted a guardian. The court might ask some questions in that case, but in theory, they could simply go in and say, I no longer want this person as my guardian. Whereas in an involuntary situation, they would need to show that they actually no longer needed a guardian. So the limitations of adult guardianship, again, it's not like in this case of a minor, an adult guardian does not stand in place of a parent, the person's parent. And they have no compulsory authority over the adults that they serve. So if I make a decision on behalf of somebody I'm guardian for, and I say, I would like you to live here, here's your apartment, here's how it's going to be set up. And the person says, I'm not doing that. I don't have any way of enforcing my perhaps well thought out, well intended decision of, nope, I think this is the best living situation for you. If they don't want to do it, the fact that I'm their guardian gives me no authority to actually make them do it. And that's true for any decision that a guardian might make for someone. People with a guardian are free to ignore their guardian's decisions. This is especially vexing sometimes in areas where you really feel like the person is putting themselves in danger, and you very much would like to have them not be in danger, and you would like them to follow your good advice. And if they have enough capacity to make their own, perhaps not very good decisions and follow through on them, there's no way to change that. This includes things like medical treatment, taking your medications. People have a right to refuse treatment, and even if we are not sure that they understand the ramifications of refusing that treatment, they still have the right to do that, and we don't have a way to force them to do the thing that we would like them to do. So guardianship does not include the powers of magic, force, or involuntary treatment or medication. And these are the situations that often present themselves as, here's why this person needs a guardian. Here's why we would like to get a guardian in place for someone, because they are making poor decisions and they're putting themselves in danger. And unfortunately, adding a guardian into that mix not only doesn't solve the problem, it sometimes makes the problem worse by sort of signaling to the person, like, okay, we think that your decision making is so poor, we're going to try to force a different decision on you. And if they have enough wherewithal to understand that that's what's happening, it can often sort of make the situation worse. And the only option that the guardian has to try to bring the person along to better decision making is to build a relationship with them to where they learn to trust the guardian, and then to maybe at least listen to alternatives to whatever the situation was that prompted the guardianship process to be initiated. And the guardian can do that, but that's not a role that only a guardian can fulfill. That's a role that lots of individuals can fill. Lots of times it comes down to the relationship with somebody and who does the person trust. And it doesn't need to be their court-appointed guardian. It could be anybody in their life who can take the time to build the relationship and get them to trust and perhaps make different decisions. So people under guardianship still maintain a whole list of rights. I won't go through all of them. The one that we just addressed is the right to refuse treatment. The fact that it's an involuntary guardianship is sometimes confusing. It does not equate to involuntary treatment or commitment. You still have the right to vote, you have the right to procreate, you have a right to hang out with whoever it is they want to hang out with, even if maybe we wish that they wouldn't. And again, that comes down to building a relationship with them to try to help them see that perhaps those people that they're hanging out with are not helpful. I'm not going to read the whole list to you. But they still have a lot of rights, is the point. It doesn't remove all of their rights, but it does take away their right to make decisions on their own, even though they can also continue to make those decisions. It's still a rights restriction. So here are some of the well-intentioned but misguided reasons for pursuing guardianship. The first is that somebody's making or will make bad decisions. This is often the most difficult situation for a guardian to have any impact on. If the person is actually making decisions, then they have the ability to make decisions. That's not the problem. If they're making bad decisions, the guardian has no way to actually prevent that from happening. And as I said before, sometimes the effect of putting a decision maker, a guardian in place, actually pushes the person in the direction of being even less willing to engage with anyone who might convince them that the decision that they want to make is not their best decision. The belief that guardianship will protect the person from themselves and others, also not something that a guardian has any easy way to. It's not the role of an adult guardian. Belief that guardianship is required to obtain or forced placement. Also not, we have no ability to force anyone to do anything, or an ability to get any particular institution willing to offer a placement to someone, particularly if they don't want to be there. Belief that guardianship will transfer liability in a difficult situation, also not true. The guardian is not automatically liable for the actions of the person that they are guardian for, unless they have participated in whatever it is that the person has done that has gotten themselves into a difficult situation. But just by virtue of being the guardian does not then make you liable for every action that the person under guardianship takes. And then lastly, the belief that involuntary guardianship can facilitate involuntary treatment, medication, or services. And this is the toughest one to wrap your head around, even as a guardian, because it's so often the thing that is presenting itself as the primary issue in someone's life that's putting them in danger often. And there's a desire to do something to protect the person. But guardianship is not that thing, unfortunately. So why do we avoid guardianship? It's a restriction. It can be disempowering for the individual if they understand what's happening. It may negatively impact relationships. This is why sometimes figuring out who is going to be the petitioner is a really difficult and challenging decision, because then you are the person who put a guardian in this person's life. And if they understand that, then that may in fact impact your relationship with the person. And then lastly, guardianship doesn't solve every problem. And it's a lot about relationships. So nonetheless, guardianship sometimes is the appropriate or maybe only option. So how do you get one? So all private guardians are appointed in probate court. Public guardians for adults with developmental disabilities are appointed in family court. Petitions for that specific scenario go to the state's attorney's office in the county in which the person lives. So the first step in getting a guardian through probate court is to petition the court. And then that petition sort of sets off a chain of events, which includes a guardianship evaluation. And then ultimately there's a hearing. The person is represented by a lawyer, and the judge ultimately is the one who determines if this is a person in need of a guardian and who the appropriate guardian is. If you have situations where you feel like a public guardian is the only available option, then we ask that you call our office first before initiating the process, so that we can A, get a heads up, and then B, also help sort of talk through the situation and make sure that we are the only option, that guardianship is appropriate, and all of the different things that go into kind of deciding if this is the most appropriate way to go. I think one of the more fascinating parts of the guardianship world is that almost nothing presents itself in the same way from person to person. Every situation is unique, and just when you think you've sort of figured out the ins and outs of guardians and when they're appropriate and when they'll be helpful, then the very next person who you start thinking about, they'll throw you off and nothing will make sense anymore. So we are always available, even if public guardianship isn't necessarily the way that you need to go. If you're just trying to wrap your heads around, is it guardianship? Is it some other sort of surrogate decision-making path that we should go? We are available to help talk through those scenarios as well. All right, that's all I have. Oh, last one. This is important, particularly for families. So the responsibility of a guardian is to support the goals, needs, and preferences of the person under guardianship. The idea is to encourage maximum self-reliance. So again, when we're talking about a guardian of an adult, this is an adult. They are their own selves, right? And their goals, needs, and preferences may be different from their family, from the people who they've grown up with, who have supported them, maybe all their lives. But the goal is for them to be the ones who are still essentially making the decisions with help, with guidance, but still the primary focus. All right, and then here's our contact information. Jose is our intake person. And then I'm also available as needed.